Okay, I'd like to welcome you all here again early in the morning. Thank you for coming. Thanks again to the Law Foundation and to the College of Law, especially to Laurie Sarowski, who organised many of the logistics here. The last session that was done here was recorded and it's now on YouTube and it's gone viral. I think it has 21 hits. So if you missed that, you can follow up by looking at that. And I think Laurie sent it out in any case to everyone who attended. I hope you can understand my accent, and just raise your hand if you have difficulties. There were some sound problems in the back, so can you hear me at the back? Thank you, that was great. I'll have you out of here by 9 o'clock. This topic we're dealing with today is especially relevant given the events that are taking place in the United States at the moment in terms of the tough bargaining between various political parties and various entities and the hawks and the doves and the moderates in each of those camps. So you may want to translate some of this across to the newspaper as you read it each day to see how some of these dynamics are playing out. You should each have a paper which has just got some outline and also another card, another one of these valuable cards that you can trade later. There is going to be a test at the end, so please be educationally nervous and have a pen ready for that particular test. Okay, the topic is how to be an effective hard bargainer, 10 methods. I'll take you through those cartoons fast. And why 10 methods? Again, human beings, we seem to struggle with very long lists if we have 47 methods, so we tend to have the 7 habits of highly effective people and the Cialdini's 6 methods of persuasion, which we'll deal with in one of the later sessions. And in the Old Testament, 10 commandments. Usually when you break down these things, they turn out to be very long with many subcategories. So the 10 is somewhat artificial, but it may help with memory. Okay, what is a hard bargainer? So we have to narrow down this particular concept, and I narrow it down in this way. It's someone who opens negotiations with an extreme offer. So in classes at the college, we're learning about insult offers and target offers. They start with an offer which is either outside the market range or on the edge of the market range. And then they frame, which is another famous phrase for geeks who study negotiation, they frame the negotiation in the sense they put in a picture frame. Every acre I get is an acre you lose. Every dollar I get is a dollar you lose. So that's how the picture frame around the negotiation goes. They use a number of tactics, which they're usually very experienced at using, and those are done to create doubt or lower your expectations, to bring you closer to their number. They make diminishing incremental concessions over a period of time, and there's a rule of thumb that each concession is half the previous one and takes twice as long as the previous one. They create tension. They're quite comfortable with tension and impasses, so this can take a long period of time, whereas other people probably don't like stress, tension. Usually the hard bargainer is quite comfortable with this. It's part of their repertoire. And when they reach the last gap, so they've moved in from 2 directions, they either split the difference, which is what we learned about last week, the ways to get across the last gap, or they adjourn and go home. And when they go home, they are able to create more tension and lead towards another meeting, another phone call. However, what I've tried to do is to say who's an effective hard bargainer, not just someone who's a hard bargainer. Hard bargainers are like people who play the slot machines. They keep telling you how they win, but when you study their record, it is not so good. I used to work in a law firm in Brisbane where one of the partners was a hard bargainer, but he was known as that around town, so people just wouldn't work with him and they isolated him. And so even though he had been effective in some situations, if you looked at his overall record, it wasn't particularly helpful to his clients or to the firm. So we've got to get rid of the word win, even though that may be around in some of the language. It's not a person who wins. An effective hard bargainer, here is a long proposition, is a person who regularly achieves, so they've got more than a 50% hit rate for his or her clients, or if they're negotiating for themselves, short and long-term commercial and personal goals, despite the risks attached to the hard bargaining process. So we're seeing in the United States at the moment many of the profound risks to the public and to a civil society in hard bargaining on both sides of the fence. Ethically, we'll do some more on ethics in a later session. We have these very challenging comments from the literature about hard bargaining, because here is James White with he's a well-known researcher in this field, and he makes this comment: a careful examination of the behaviour of even the most forthright, honest and trustworthy negotiators will show them actively engaged in misleading their opponents about their true position. To conceal one's true position, to mislead an opponent about one's true settling point, is the essence of negotiation. So here he's commenting, when you get into positional bargaining, when you get towards solutions, all good negotiators, as I mentioned to you, can read upside down, and so you hide certain facts. You don't lie, especially if you're a lawyer, but you hide certain facts. It's like playing poker. There's a stony face or a smiling face which hides certain things. And you've got his even tougher statement on the next spot. On one hand, the negotiator must be fair and truthful. Reputation's everything in negotiation. You need to be known in your mini community as someone who is fair, someone who is truthful. If you're not, that will have long-term pragmatic consequences for you. But on the other hand, he says he must mislead his opponent. Like a poker player, a negotiator hopes that his opponent will overestimate the value of his hand. So here are the 10 rules, and I'll just list them for you, then I'll take you through these. And there's opportunity for questions at the end, and certainly comments, because many of you will have been involved with people who are hard bargainers in this sense. They use these strategies, they use these tactics, and they are effective in a number of situations. So that you've got to work out which situations. So the key first rule is diagnose carefully. Don't use these patterns, and hard bargainers don't use these patterns if they are effective in certain situations. They know the situations in which to use them. Second rule, prepare, prepare, prepare. Especially the horrible acronym you've got there, BATNA. What's the best alternative if we walk out of this phone conversation, Skype, or meeting? What's the best alternative I have to a negotiated agreement? And lawyers particularly add, and what's my worst alternative? What's the worst thing that can happen if we don't cut a deal? And that's what the Democrats and the Republicans are discussing, of course, of what's the worst that can happen if a deal is not cut. Next, an effective hard bargainer prepares doubts. They're masters at creating seeds of doubts in your team. And they often have colloquial methods of doing this. They don't use technical language, though they could do that. They have stories and nice phrases which stick in people's minds about what's the downside here if we don't move towards their number. They're control freaks. They control the process. They teach their own members the dance. What's going to happen? Be patient. So in my world, I've often seen clients crack while we're having negotiations, because clients can't stand the stress of this game, and they will say, oh, let's just get out of this. Let's just buy out fast. And so you must constantly teach your team, unfortunately, this is a dance if we're going to do it, and it's going to take time and pain. Effective hard bargainers are great at asking questions, particularly open questions, as we'll see, such as, could you elaborate on that? Or they play a bumbling Columbo and say, I'm confused, can you help me with that? That's like being helped by a cut brown snake. They disclose information selectively. They don't lie for reasons that are particularly apparent in small communities, but they don't choose to give you everything. They don't tell you that they need this deal by Friday. They don't tell you that they're opening another branch in Hong Kong in a month's time. They unite and divide teams. So they divide the opposition. It's a very important strategy that's used by them, and therefore unions often won't allow their groups to meet with these kinds of bargainers. They'll only allow one person to meet because they're fearful of division. They unite their own team. They tell their own team, We're going to have a meeting. We're going to work out who talks. They selectively use tactics. So it's not Hollywood. We'll get to that. And I think there are many dangers in using tactics. There's only one tactic that I really encourage you to use in a soft form. And this is interesting. They know they have made many mistakes in their lives. So they're accustomed from experience that they have made errors. And those errors are known as cognitive heuristics, again, for negotiation geeks. But they're known in experience just as I have made this mistake in the past. I have overestimated, underestimated. I have made assumptions, and what we learn at the college is assumptions make fools of all of us. So I'm going to take you through those and just elaborate on those, particularly the first one. Okay, so diagnose carefully and continually. So don't use this methodology because it's your MO, you just use it all the time. That's like being a doctor. I always cut. I always go for the brain. I always pull out the scalpel. All right, so beware of hard bargaining in the sense that we've defined it, where continuing relationships are important. So in the global village, continuing relationships are important more and more than they probably ever have been. So if you're negotiating with a valued employee, you may talk about constraints that are upon you, constraints that are upon the future budgets, but you try not to be a hard bargainer in the tactical sense because you are going to need this person in the future. You want good relationships. So there are many situations where those continuing relationships are important. I did a mediation on the Gold Coast in Australia which was between a developer who had remodeled a factory and the owner of the factory, and the owner was disappointed in the remodeling of the factory. It didn't produce at the rate he was hoping. So they got into very hard bargaining, whereby they each sued one another and had a big team of lawyers. The owner of the factory saying, I'm suing you for negligence because it's not producing at the right rate, and the developer saying, I'm suing you for defamation and also for you didn't pay the last $250,000 to me. So it was very tough bargaining along single lines. We had 17 people in the room, and one of the young lawyers, to his credit, came up to me and said, John, we've got to get out of the room because there's too much noise in here, which is always a dilemma of negotiation. So the two CEOs, I asked them would they come for a walk with me, and they did. We walked for an hour and a half around a Melbourne suburb because we actually moved the whole negotiation to another city. And what we discovered is that they had, because the developer, because the remodeler was such an expert, it was inevitable in the future they were going to have continuing relationships in that particular industry. And so the whole nature of the negotiation changed between the two CEOs, and by the time they got back after an hour and a half, they'd drawn up another contract orally to remodel another building. So the whole nature of it switched. Speedy outcome, if you need a speedy outcome, excuse me, you need to be very careful of hard bargaining, because hard bargaining will tend to create tension and people will want adjournments, go away. I want to think about it. I want to speak to my expert. So if you want speed, you need to think about a different method. So here are these horrible acronyms where your whatness and your batness are uncertain or risky. So in other words, your fallback position is uncertain. If you leave here without a deal, it's not clear whether you have alternatives, an alternative factory, an alternative car, an alternative employee, or whether the litigation is clear. And we all know litigation's not clear. The opposition are time-rich zealots. So in Western democracies, we're all in a hurry. So time-rich zealots are very difficult people to work with. So again, where I came from, the Gold Coast, there were many retired judges, and they would retire on housing developments. And whenever they bought a property on a housing development, the developer would shake usually his head and would say, oh no, not a retired judge, because retired judges probably have another 20 years to live before they die. And they also are accustomed to a lot of attention. And so they would negotiate about the gutters, about the bump in the road, about the grass on the sidewalk. And the developers had learned just to give in. Whatever they asked for, you just do. because these people can become a stone in your shoe for 20 years because they have nothing else to do. Likewise, if you fear long-term bitterness, so this is very much related to continuing relationships, if you fear that your strategies of being a hard bargainer will create long-term memories, and remember, most people have long memories when they get hurt, and there will be payback times when you apply for a job somewhere else, when you work in another county, another city. So be careful if you fear that, and I'll give you an illustration in a moment. This is a horrible phrase you'll see in all the books, but just remember, I've never been to a negotiation which is just about money. Never, ever. So many lawyers say to me, John, this one's just about money. But when you meet the people, that's not the case. There's always emotional factors, and there's always what we call procedural factors. So you've got a three-sided triangle: substance, emotion, and procedure. And so the content, the hard dollars or the hard land or the hard return of goods, whatever it may be, is always qualified by these extra things. And if you miss that, you're a sloppy negotiator. You won't get hired because you are missing some of the extras that are around. And these last two are interesting. I particularly make reference to Australia. I'm not familiar enough yet with the Canadian legislation. Slowly, legislation is building up to try to crush hard bargainers. The irony is, where does the legislation come from? It comes from legislators who are tough bargainers, especially in the United States. So legislators don't like to see so much resources put into industrial negotiation or courts where people are playing games with being tough. So they try to pass laws which have good faith and all these weasel phrases in them. Likewise, there are arguably expanding ethical guidelines, particularly on lawyers, which say, be careful when you play these games, be careful. So I'm going to take you through those. We'll just have a quick look at the last two, and this is a friend from Australia who has developed this theory. He calls it the puddle in the sun. So normal competitive behaviour involves turning up late to meetings, sending juniors to meetings, refusing to make the first offer, asking the other person to make the first offer. So there's a whole range of strategies attached to being a hard bargainer. And what is happening in Australia is a number of pressures are coming on that puddle so that it is shrinking in the sun. There are more and more cases where lawyers particularly are being disciplined by their law societies for particular tactics they use. Legislation, there's now 150 statutes in Australia which have the phrase good faith in it, whatever that means. No one's very clear, except that good faith varies according to what kind of area you're negotiating in. So good faith in Aboriginal negotiations is a huge topic, whereas when you're negotiating with bankers, it's a tiny topic. So the Trade Practices Act, which is it was a federal act in Australia, has this section in it, or had this section, which is called Section 52. It's called the Exocet of Negotiators because it's a missile which forbids misleading behaviour. So it forbids half-truths, and many people have got into strife. It's since been amended and has another horrible name, but you'll see most of the literature talk about it as the TP Act. And so these kinds of pressures may be worth taking into account diagnostically when you say, shall I behave in this particular way? Once again, we'll do more on ethics later, but I'll take you just to this famous extract from the ethical codes of the American Bar Association, which has a lot of publicity. So what ethical constraints are there upon lawyers particularly? Could be real estate agents, could be architects, could be engineers. You'd have to go to their particular codes to see whether there are ethical constraints as compared to legal constraints. And so the American Bar Association has a form of crass honesty in their code. So they come up with a whole bunch of things that while you're negotiating, you shall not use certain tactics. So you cannot make up defenses or legal arguments that you know don't exist unless you are trying to extend the law by a new argument where you're saying the law needs to be changed because it's not working. Likewise, lawyers can't hide information during the course of negotiation, particularly say with an insurance company. You've got to be upfront and tell insurers all about your client. You shan't use perjured or false evidence. You shan't knowingly make a false statement of a material. And everyone put a circle around a material, the weasel word, of fact or law. And you've generally got no affirmative duty to inform a person of facts. Now comes the kicker in the United States. So here is an expanding form of deception for American lawyers under their codes. So what's the ethical code? Under generally accepted conventions of negotiation. In other words, everyone does it. What's the ethical code? What's called normative in the books. If everyone does it, you can do it too. So the American Bar Association says certain types of statements are not taken to be material. Which are the statements? In other words, you can lie about estimates of price. My client's worth $2 million, lie. This business is worth $40 million, lie. You are authorized to lie about price. Why? Because everyone does it. And likewise, you can lie about your intention to go to court. You can say, if you don't take this offer, I'll take you to court. Lie, you're not going to court. But you can say that because ethically that's okay. Now, whether you couldn't do that in Australia because legally you're not allowed to do that. The Trade Practices Act would catch you. So my experience, in case we feel righteous here, are that Canadian and Australian lawyers have 4 constant lies they tell to me as a mediator. If you like to write down 4 lies. So we're not so righteous. I find the Americans are more honest about their dishonesty. First lie, this is my best offer. Lie. Almost always lie. This is our bottom line. Lie. Just standard. It's said so often as a lie, it's like I love you, it becomes a lie. Okay, our experts support this conclusion. Lie. The experts never support the conclusion. The experts have been given garbage in and they're given garbage out. So we'll do another paper later on, dueling experts. And then, if you don't take this offer, we're going to court. In other words, same as in the American Bar Association statement. And that's just not true. So those lies have been told so often that no one believes them. So when I talk to lawyers about this, they say, John, those are no lies. They're not lies because no one believes us anymore. It's interesting logic, isn't it? Yeah. Okay. So we're still on diagnosis. Be careful when you go this route. The reverse, get your diagnostic chart out. When should you use these strategies? When one believes you have nothing to lose. The most powerful negotiator of all is someone who says, I have nothing to lose. I've just done a mediation in another city in Canada, and it was a professional negligence action against a big law firm who allegedly advised a bank incorrectly and drew documents incorrectly. So the lawyer acting on behalf of the insurer, the professional insurer, arrived and said to me, John, we don't care if we lose this case, because if we lose it, that'll be an example to other people that we're very dangerous people to negotiate with. We will run this into the ground, and even if we do badly, we win, because everyone else will be scared of us. And by the way, my insurance client has a deep pocket, so they're not afraid to pay out big amounts of money. Interesting comment from a lawyer acting for a professional insurance organisation. But he was saying, I have nothing to lose. So my offer is 0. Next, need to preserve a tough reputation to avoid floodgates. So listen to President Obama as you watch the particular debates taking place. I cannot give in to the Republican demands. If I give in on this demand, every time there's a budget to be passed, we will have a similar form of negotiation. So I have to be tough. I have to go to the wall on this because of floodgate. Next, if I'm an insurer particularly, I have to be consistent with past decisions. There's a form of justice to award a paraplegic the same kind of damages that other paraplegics are getting. This is a tough one. People become hard bargainers when they're filled with emotion and hurt. They're grieving a loss, and they will just stick to a particular point because this is playing out their hurt. So it's a diagnostic factor, but it may not be a sensible one. Then back to this, I don't care about relationships. Next, this one is a tough one. A perceived benefit in delay. So I used to do a lot of matrimonial property mediations, and this particular scenario was where usually a wife was in occupation of a home, a nice home with her family around her, with neighbours around who were supportive, and she had a stable income due to investments, and her husband was running a risky business, horse racing business, construction business, and of course he wanted to cut a deal so he could borrow more money in order to continue the business. But the wife, usually counselled by a tough lawyer, would say, just string him out. Just string him out. So string him out for 2 or 3 years because you've got a comfortable life, comfortable friends, comfortable income. And basically, he will either crack or his business. The risk is, of course, his business will crack too. But if you wait for 2 or 3 years, you can stick on this percentage and eventually he will crack. Perceived benefit in delay. And attached to that is this concept of power, which is important. The lady in that situation perceives that she has time power on her side, and her power can be exercised over a business person who needs to make fast decisions and borrow more money. So factors when you stay away from competitive strategies and factors when you adopt them. Okay, we're going to have a little exercise here. All the people in my class can't go through this exercise. So what's going up on the board is a sentence. You are to count, it'll only be up on the board for 4 seconds. You are to count the number of the letter F's in this sentence, F not including the title. And then you have to declare your number. You'll only have 4 seconds. Are you ready? Off. Okay. Everyone must now vote. If you don't, there's an electric charge in your chair. How many F's? I'll call out the number. You raise your hand. 1, 2, 3. A lot of 3s. 4. A few 4s. 5. 2, 5, 6, 3, 7, 8. Okay, another chance. Are you ready? 4 seconds again. Going off. Okay, how many F's? We'll try 2. A few 2s. 3. A lot of 3s. 4. 4s have increased slightly. 5. 5s are the outliers. 5s. You must feel like social outcasts. 6. 7. 8. Last time, everyone. You ready? 4 seconds. Going off. Okay, we'll have one more voting round. 2, 3, 4, 5. More outcasts. 6, 7, 8. Okay, let's count them. Here we go. 1, 2, 3, 4, 5. So at the college we then go through how many ratios, how many principles you extract from that particular exercise, and there are many. There's probably about 20. But one of them is in every negotiation team you need a dissenter, because if you get groupthink happening, then you perceive situations incorrectly. So diagnostic, this is all related to diagnosis. You need to have some kind of systematic preparation. So you've got there on the next slide you've got is a diagnostic chart which was developed, if you want to write his name there, by Christopher Moore, M-O-O-R-E, who is a well-known mediator from Colorado. And so we experienced there a data conflict. We all looked at the same situation and saw dramatically different things. So data conflicts. So hard bargainers, in their own way, engage in diagnosis. What is this all about? Is this just about money? Is this caused by people seeing the same situation but seeing it differently? What is going on? The tough negotiations are usually value conflicts. So this is what's taking place in universities and law firms all over the world as we stand here. So value conflicts consist of experts and lay people, and people become very fixed in their positions, engage in tactics with value conflicts. So I did a long 3-month negotiation between parents of dying children in a hospital in Australia and the medical profession. And so you have experts versus lay people, each having views on how dying children should be treated. This is the one that's ripping universities apart across the Western world, is how should they be managed by MBAs with skills, top-down leadership in terms of number crunching, or by the people at the front line, the people teaching, the students. How far should you have top-down or consultative management? Of course, the environmental ones, lying and never lying. We've just had the tensions there of lying and never lying, or half-truths in ethical codes. This is the one that's ripping law firms apart all over the world. Income versus balanced life, the work-life balance is how to achieve that. So many people exiting the legal profession based on this tension. Individualism and community, what's more important? Is I, me, mine, looking after myself, or is there some sense of community where you can sacrifice your house, your corner block, your size of your lot for community interests? And of course, cross-culturally, dissent and respect for elders. Where is you can't prove value conflicts by data. They are beliefs as to the meaning of life, and they lead to tough negotiations. There's a Norwegian writer who says all values can be converted to numbers, and so therefore it is possible to reach conclusions through negotiation. Next, rule 2 of hard bargainers: plan, plan, plan. Prepare, prepare, prepare. And don't do it randomly. Don't sit around over a glass of wine. Have some chart, systematic preparation. So there is one of many, many negotiation preparation charts. The key things are to know your fallback positions. This column, is my fallback position if we don't get a deal? And of course, the central column, we're assuming hard bargaining. We're going to compete. My win is your loss. But it's absolutely essential to get this column going. What are my goals and priorities? What's the goals of my teams? What's the different goals of the people within the team? So planning instruments of some kind are essential and are used by hard bargainers. We looked at this last week. The hard bargainer also understands that every line has 6 numbers on it. If you're negotiating about pay, 6 numbers. If you're negotiating about time for next review before the pay is looked at again, 6 numbers. If you're negotiating about percentage raises based on standard of living, 6 numbers. If you're negotiating about time for holidays, time for sick leave, 6 numbers. And each of those are important to have at least written out on the back of an envelope so that you are prepared and your team is prepared for what may be the ranges. Next, rule number 3, a hard bargainer is really expert at preparing doubts. They understand doubts. So you've got a chart which I really encourage you to use in your work life because you need to be able to say these doubts harshly with maybe a few swear words, and also very gently. So linguistically to say, well, I'm having some difficulty with, I was wondering what we should do about X or Y. Could you take a moment and just go through that chart? I'll give you 30 seconds and put a circle around the doubts you see used most often in the world you occupy. So just so you know, lawyers, we standardly use 1, 2, 3, 4, and 8. Those are standard lawyer talk. You should come towards my number because of 1, 2, 3, 4, and 8. Facts, evidence, credibility, rules, and direct costs. Business people usually use other doubts. They're more interested in some of the others. So just if you go through and put a circle around the one you see most often, we've already seen President Obama, number 14. 14 is his big speech at the moment. If you want to write next to 14, this is the major argument of all middle managers, university presidents, bankers, lawyers. This is the major doubt. I cannot create a precedent. I can't treat you differently. You are one of 200. Okay, can anyone call out the one they see most often in their world? And there'll be different chess moves according to which world you occupy. You need to learn these, everyone, because when you go to a negotiation, you can make it go really fast. You can just walk in and say 1, 3, 4, and 7, and they can say 8, 11, and 12, and you can go home. Okay. So you need to know these. Okay, the most powerful negotiator is number 12. Be very careful when you meet a number 12. I don't care, I don't care, I don't care. If they're telling you the truth, in a workplace situation, be very careful. They can make a real mess of things because they don't care. They don't care. Your job is to find something that they care about, because the person who doesn't care is a classic terrorist, and in fact they will enjoy the martyrdom of being crucified. So just so you know, in my world, 16, 12, 14, 16, 12, 14, and 9 is the big business one. How much money are we losing by sitting around talking? All right, so hard bargainers understand these moves and they make them very well. Softly, usually softly. They don't have to swear, they don't have to scream. And they have a series of phrases. I've given you some of the language on the next handout. It can be said softly, predictably, Bill, I disagree with everything you've said. So it's not, Bill, you're an idiot, you've got everything wrong. So the various phrases that can be used which are creating doubt softly. But there is a time, of course, to swear and scream. There's some people, linguistically, that's how they communicate. Okay, rule number 4, be a control freak. The hard bargainer controls the negotiations. They control the process of negotiations. So you see some of the methods of control. We won't meet until you've done another valuation. We won't meet until Bill is back from the holidays. So these are preconditions to the meeting, preconditions to the email exchange. I won't meet until you have set out your 4 objections in a 1-page email. Schedule meetings at your own convenience. We have a boardroom available. On Friday afternoons, we can provide you with sandwiches. You lower expectations early. I think I understand what you are needing. You need to know that we will not be able to meet all your demands. You need to know that we are under severe budget constraints. Hard bargainers often say, I can help. It's like the crocodile with their mouth open. I can help. The hard bargainer knows that there are transaction costs attached to hard bargaining, that you'll have lots of adjournments, and so they reduce expenses. And this is a tension because they may send a junior for the first 4 rounds of negotiation before they send a senior. Sending the junior is the kiss of death. But they're trying to do 2 things at once, cut costs, but also have negotiations. They take regular breaks. They don't ask for permission for breaks. They say, we'd like to have a break in 5 minutes' time. We need to talk through with A or B. They ask the opposition to do work. Can you prepare the 40-page document? Can you prepare this? Can you have a fresh valuation? So they're making the opposition engage in transaction costs, slowly wearing down the opposition. They make alternative offers. Good negotiators make alternative offers. Here is a pay package which has a lot of money up front, but little afterwards. Here is a pay package which is spread out. You'll see they come to equivalent numbers really, but the rate of payment differs. Very, very effective kinds of negotiation. When the other person gets aggro, when the other person flips their lid, they are extremely polite. I see your client is very distressed, John. Would you like to have a break to talk to them? Thank you very much. I wonder why they're so distressed. So they are good at appearing to be the angelic force in the room. Could we come back to the topic? Would you like a cup of coffee? And very importantly, they don't walk out. They don't walk out. They always get something. They get some concessions, some offer, another meeting, some new documents. So they are wearing you down by their successful attrition of mini agreements which help them. Next, they teach the dance. They know the dance. They've been there many times before. They teach the dance to their team. So the dance is be polite and clear. Start high soft. Let's start with a high offer, but give some code that you're going to move. Or start on the edge of the insult zone. But be careful of the insult zone. Remember, the number which has no market support, dangerous, because you could create a terrorist. Use objective criteria. Here are the precedents. Here is the policy. Here is the statistical pattern. They ask a lot of questions, and they're teaching their team. We're going to ask a lot of questions. They know the doubt moves that you've got. They never give you anything unless they get something back. We'll move 10,000 if you move 10,000. What if we were prepared to increase the number of days of holidays? Would you be prepared to do X? So notice it's what if. They know that the timing will drive their team mad. Each concession takes twice the time and is half the previous one. They don't try and go fast. They know fast is death. Fast is death. Just slow it down, slow it down. When they get close to the number where they will have to say, sorry, can't go any further, they're very careful to avoid what's called add-ons. Apart from the money, apart from the land, apart from the property, apart from the holidays, is there anything else? They don't want to be ambushed by, oh, there's one more thing, there's one more thing. They are very good at what's called breaking the pattern at their resistance point. So I see this particularly with lawyers who are expert at this. They say, they have a speech, it goes like this. They've been making incremental concessions, and they say, John, your client's been so good today. We really appreciate them. They're fine people, and we'd really like to help them. And so you probably know that we have to spend another $21,000 on renewing the valuations and also getting a second expert's report, and we have to spend that on Friday. We've got the appointments made. Now, as your client's such a nice person, I'd prefer to spend that $21,000 on your client rather than on these terrible experts. So what if we did that? So this is breaking the pattern of incremental concessions. You're having what's called an exploding offer, an offer that disappears on Friday, not because you take it away, but rather because you've spent the money. And whenever you adjourn, you've got to teach your team, there will be adjournments. Get something. Don't have fruitless meetings. Always have some concession in your direction. So there's another process, negotiation process, which they know about. So I've given you, they have knowledge of the dance, and they teach their team the dance, and they teach their team patience, patience. Rule 6, ask questions. Why? They particularly ask open questions. Tell me more. Could you elaborate upon that? They're hoping that someone in the team will blab and talk about what we're really looking for is X. They're hoping that They can, by asking questions, so what evidence do you have which supports this particular severity of injury? So they emphasize evidence. We have two pieces of evidence. We have a videotape and we have this doctor's report. They ask questions to avoid groupthink. They're used to making mistakes, so they want to see whether they are making mistakes with their presumptions by seeing what comes back. I did a mediation with a group of farmers in Queensland, and the insurer was really rocked by the group of farmers, brought along their spouses, so the 8 of them subjected themselves to cross-examination, and all of a sudden the insurer realised he had 8 brilliant witnesses against his version of the events, and the offers escalated dramatically. Ask questions to search for extra chips. Is there anything more than money, land, respect here? And interestingly, to demonstrate empathy. Even though I am a tough insurer, I have some sympathy, empathy for your suffering. So hard bargainers disclose information selectively. There's a 30-second exercise for you. Could you write out at least one method, it's got 3 there, whereby negotiators you've met make selective disclosure? They don't tell you everything. Do they do this by sending you half the documents? Do they do this by only answering a quarter of the question you've asked? What's the methodology used for not giving you everything? For example, some lawyers say to me, well, John, of course that's confidential. That's maybe code for, there are some things going on here which we're just never going to tell you. What are the methods used, which may be code methods? They may be code known within that culture, that we're keeping back certain things that we're not able to tell you. And sometimes the phrase is for commercial reasons. Right, very important. Hard bargainers understand unity and division. And so when you're negotiating, you're never negotiating with a single person. You're negotiating with a person, unless they're very socially isolated and going through mental health problems. Everyone has someone in the background, a cousin, an uncle, an accountant, a friend, a business partner, who is influential in the dispute or the negotiation if it's a transaction. And we'll do a session later on how do you locate the outsiders and what do you do about them. So the outsiders are classically called hawks, moderates and doves, and your job is to create subcommittees between the moderates. If you were to get a deal, the hard bargainer understands that. The moderates are the key to getting a deal, because moderates are willing to give something to get something. If the doves can dominate, that's great, but they rarely can dominate the team, because a dove will just give in. A dove will give in. So that's what President Obama is hoping to find in the Republican Party, some doves who've got swinging seats. The hawks you've got to get rid of because they are problematic, and the hard bargainer will usually associate eventually with these moderates, even though they may initially appear to be a hawk. So I found, as I may have mentioned to some of you, that spouses are key players in negotiations. Spouses of tough bargainers, you get them involved either in the background or actually in the room, and they become the moderates, whereas the client up front here may be playing out the role of the hard bargainer. This is one of the reasons that mandatory mediation, as long as it's in the same room, is so effective, because you've got the teams in the same room and you can break professional privilege by negotiating with the client on the other side of the table. But unfortunately, many mediations have been bastardized by the legal profession, and they put people in separate rooms straight away, and you lose the major benefit of mandatory mediation. Next, selective use of tactics. So here are some of the tactics that you would have all seen. An extreme opening offer could be in the insult zone, using rudeness, hostility, try to intimidate, remain silent, have ultimatums. If we don't settle this by Friday, then there'll be a strike. Stalling, don't answer correspondence. Withholding any concessions, or when you're asked for information, just giving nothing. The standard, oh, I'll have to talk to my boss. Oh, I'll have to get instructions. Oh, I'll have to go back to the tribal group. Not because that's true, but it's just a tactical way of saying I have a tough person in the background. Stretching the facts. Now, this is the one I think that everyone should do in a moderate form. I don't agree with any of the others. I think your reputation is immediately tainted if you're a repeat player. But playing good cop, bad cop is an important one in a moderate form. Why? Because good cop, bad cop represents life. There is cooperative life, and if we can't cooperate, there is less cooperative life. And the bad cop represents the less cooperative life. Work with me, or you'll have to work with the boss. Let's cut a deal about the cheating that took place in the exam, or else you'll have to work with the university committee. Let's cut deals that way. So here are some of the good cop, bad cops in Australia. In some places, there's a divided profession. So often the solicitor is the good cop, and the barrister is the bad cop, though sometimes it's vice versa. Sometimes you have a raving barrister, sometimes it's a soft bad cop. Lawyer, accountant, I find accountants are great moderates for settling disputes. Disputant and spouse, spouses are great. I try and get spouses involved in as many negotiations as possible. The middle manager and the boss, the middle manager is a good cop, the boss is the monster in the cupboard. The client and the lawyer, the client's raving, and the lawyer says, deal with me, I can manage the client. The worker and the union leader, the expert witness and the lawyer. I've had very good experiences with expert witnesses who become the moderates and are able to talk about this is normal in this situation, there are ways around this. And the client and an evaluative mediator, and the individual and the same individual. I've coached some people to have fake tantrums to become the bad cop and then apologize and become the good cop and move on. So it's a bit schizophrenic, but it's had some amazing success. So there's a cartoon. I'm going to get you acquitted, but I want my fee to be a lesson to you. Okay, rule number 10. Even though hard bargainers don't read negotiation texts and know technical language, they have experience which allows them to talk about technical language in colloquial terms. So these are known as decision traps or cognitive heuristics. That's the geeks phrase. And these are very important. You learn them in Psych 101. Every human being is hardwired to make bad decisions. And hard bargainers know this because they've made some bad decisions. So here are some of the hard wiring. They're called shortcuts. Life is so complicated that we have shortcuts to help us manage. So the hard bargainer knows that if he gets a number out on the table quickly, that number tends to drag people towards it. The person who speaks first gets the anchor out, unless it is an insult offer and you've got a good person on the other side. So the lawyer says, I won't even take that offer to my client. I will not allow that offer to be mentioned because it is going to inflame the situation. So human beings tend to over-rely on first thoughts. We tend, as hard bargainers, to say, well, we've gone down this route, we've spent 6 weeks and $100,000 on this solution, so we're not backing off. We protect earlier choices irrationally. We believe this is just about money. That's usually false. It's just about money. It's about money and some other things. People tend to keep with the status quo. It's comfortable to stay in my job. It's comfortable to keep the universities functioning in this way. Status quo tends to then govern decision making. Confirming evidence is devastating. We see what we want to see. We see that someone's smiling, therefore they're laughing at us. They don't answer our email, therefore they're stonewalling. We see what we want to see. The framing trap, we've already seen that in a number of situations where we put the dispute in a particular picture frame and say, it is just about X, so you get the wrong answer because you've asked the wrong question. Remember, I think I've mentioned this to you before, always take a one-page summary to every negotiation, if possible with coloured pie charts, if possible with colours on it. Human beings are unduly influenced by one-page summaries in colour. That's how it goes. So when you're given one, you better know what's happening to you. Hard bargainers know, and they bring along these one-page charts. Hard bargainers know that there will be regrets. Once the deal is cut, they must deal with the aftermath, the post-settlement blues of, oh, but we could have done better. Oh, but we could have done better. And people then having bitterness and wanting to back out. Overconfidence, legal profession particularly, is not only hardwired with overconfidence, we are trained to be overconfident, and that overconfidence leads to many mistakes. Being sure of our ability leads to many mistakes. I'll give you an example here. I have to talk loudly because I've got to go away from the microphone. But I mentioned this one to the class. I was involved in a negotiation with big numbers, but it indicated the principles. A mining company suffered floods, and those floods stopped the production of the stuff they mined, and so they made a claim against the insurers, and the insurers were based in Europe, and there were 29 insurers in a chain, and because there are 29, it's hard to muster cooperation, so they had an agent who classically cut deals. So the agent was overconfident of his hard bargaining MO. He had a method which he used, and so here's how the method goes. He phones up the CEO of the mining company, says, why don't you come to London and we'll have a few meals and drinks and we'll cut a deal on this claim. Without all the facts, but we can't wait for all the facts, it's could become very complicated. So he gets him to come to his place. That's his MO. He gets him there, wines and dines him, his MO. Then he says, predictably, what's your offer, to the head of the mining company. The mining company boss made a mistake there and gave him an offer. So his offer was 450 million. The insurer said, well, that's interesting. And he pulled out from under the table a report. We've just had a report done which shows that the maximum you'll recover is 200. So next strategy, ambush the other side with a report. A prosecutor report based on garbage in, garbage out. So his next strategy, standard insurance strategy. But the strategy, he's overconfident that this will work because he's used it many times before. But it backfires because when you're negotiating with the gorilla may get angry, which was what happened. The CEO got angry, bitterness on the table, went back to his homeland, and there began negotiations. And so the negotiations went on for another many months, and then I was involved because I was involved coaching the CEO for the next round of negotiations. So he went to the next round of negotiations, and so what was his opening offer? He agreed to open the next time. 800. Well done. 1.3. So 1.3 billion is his opening offer. So we now have a response to an insult offer is an insult offer. So he's now being coached on how to behave. And so they sit around for several days. And what was the settlement? $667. So playing the old hard bargaining game diagnostically was done to the wrong person, a strong person with time on his side, put bitterness on the table, and he came back as an educated negotiator with standard hard bargaining strategies the other way. So be careful of overconfidence. I won't take you through this, but just back to Disraeli, there are lies, damn lies, and statistics. Many people are unduly influenced by statistics. When you analyze the statistics again, you discover that they have a false starting point. I won't give you examples now of that. Self-serving bias, this is very important. I think we've talked about this before. It's called, again, the fancy name, attributional distortion. Human beings say that I am having trouble because of the environment. I'm having a bad day, I'm under pressure at work, I am ill, so I'm having trouble with the environment, but you are morally defective. You are lazy, you are... So we naturally give blame to other people, but to ourselves we're under environmental pressure. So that's our natural wiring, and again, as lawyers, we make it worse because all legal training is to attach blame, not to attach environmental explanations. And ignoring people's interests. We are wired not to listen. Let's get down to business. Let's get down to brass tacks. So hard bargainers understand these without ever having read anything about them at all. They just know, I have made lots of mistakes in the past. Presumptions make fools of all of us. They have these nice sayings whereby they haven't researched any of this, but they have a working knowledge of it. Our reactive devaluation, we tend to devalue good ideas from people we don't like. Very important concept. Good ideas are devalued from people we don't like. Therefore, it's key to give your good ideas via a person that the other person likes. In other words, lawyers don't carry offers. Get other people to carry offers, because once they come from the mouth of a lawyer, they must be damned. So we've got standard comments to avoid. It's only money. The other side won't take the risk. We can agree on the facts. A whole bunch of statements which you hear, which you need to drop out of your repertoire, and hard bargainers modify their statements because they know that some of them are just inflammatory and no use at all. All right, now we get to your bubblegum card. What are some of the effective responses to positional bargainers, to hard bargainers, to people who use these strategies who go straight to solutions? And there are many possible responses here. I'll take you through some on the board. You've got an expanded version in your card. It's important to discover people's reputation beforehand. Ask around. Have you ever worked with Jane? Have you ever worked with Mary? What's her MO? We tend to be trapped by our standard patterns, and therefore guard your reputation. It's sacred, because if you become known as this uncooperative person or this person who goes straight to solutions and uses tactics, people will work a way around you. So if you know you're going to meet someone like that, at least you start prepared. You must do a risk analysis. We're going to do that in the next breakfast session. In other words, you should expect adjournments. You should expect to be jammed. You should expect some tension. So what are the risks if we walk out eventually from that negotiation? Know your best and worst alternatives. You must have alternatives. You must date them. Put a date. We have these other choices: to get another job, to buy another factory, to go to litigation in another jurisdiction. Withdraw all existing offers. So this is inflammatory in itself, but when you're dealing with a hard bargainer, remember, they're making you do incremental concessions towards their numbers, whichever the lines they have on their numbers. So when you go to a big negotiation where you're trying to get a final deal, a wise step is to say we withdraw all previous offers. We're starting from scratch again to see if we can get a package. Could be inflammatory, but certainly in my world that's used a lot. Make a first offer, try and speak first. You've got to go close to the insult zone because you know that that's where they're going. Or you say we have 5 topics to work on. You avoid numbers to start with. When they use wild offers, you should name them. So that's your insult offer. Is it John? If they're using a strategy, it looks to me like good cop, bad cop. Is that what's happening in this room? Name what's going on. They will probably laugh when they realize it's named. Normalize what's going on to your team. Your team will have moderates and doves in who just say, this is too stressful, let's cut a deal. You've got to educate your own team. You've got to educate the other team because they may not be well educated. So write your common goals, 1 page, remember. I think we have these things in common. University administration, workers. I think we have these things in common. Family member, family member. And then 1 page, here are our strengths, here are your weaknesses. They need to be educated by short documents. Split their team, have several lines of communication. Don't just talk to the upfront person. So during coffee breaks, talk to other people. When you finish the meeting, phone other people. A lawyer can't phone a client, but a client can phone a client. Only make concessions if you get something in exchange. What if we moved on this? Are you prepared to move on that? Not, we will move and wait for the next move. Minimize expenditures, because one of the strategies, remember, is to get you to spend money all the time on transaction costs and slowly wear you down. Suggest an independent expert. We seem to have difficulties with the evaluation of this farm. We seem to have difficulties with what other businesses are doing. Could we hire an expert to give us a one-page opinion based on joint facts? Usually the hard bargainer will refuse that. The fact that they refuse it is a sign to you that you are dealing with someone who really doesn't want that factor up front out on the table. Occasionally use tactics. The only one I suggest particularly is you have a good cop, bad cop routine. The others can be too inflammatory. And if necessary, if you're in a litigation situation or a conflict situation, you may need to file early in order to get exchanged information. Filing early is inflammatory, but you may have to explain it on the basis that filing early is only done to gain information. So you've got on your card a number of others. Number 15 is particularly important. That's what's going on in the United States at the moment. Backdoor negotiations with other tribal members. We've run out of time, so you're going to miss the test, which is going to be a heartbreak for a lot of you. So we'll look forward to next time. Those of you who can come, it's on risk analysis then. Thank you very much.